Hi.
So what's hot now?
Pens.
From which era?
80s. Late 80s, early 80s, late 80s, early 90s.
You were in a pen shop in Montreal?
Yes, I was. And I almost salivated.
Do tell.
Lots of pens.
You love pens, I know.
I love pens. My Waterman, I have a late 80s Waterman. You know the fountain pen? Green top, gold.
Yep.
I have that.
Oh,
and
wow.
I asked the guy, yeah, I think I paid $250 for it. What's it worth now? His jaw like dry. He's like, oh, you could probably get close to $800 for it.
Wow.
Like, what? And Filofaxes? Remember those? Come on.
No.
The day planners, the English day planners made out of leather. Everyone had them in the 80s.
Filofaxes?
Filofax, yeah, they're leather planners.
Well, I have my leather day timer still.
Same
like
thing.
That's what I use for. I don't just rely on like our computer system.
Oh God,
because our computer system gets hacked and viruses and shit. So I have literally a day planner since 1993. And by the way, since we were discussing on our previous episode, this is my Waterman pen from 1993 that I bought, which I use in every trial. And if I thought I lost about 5 or 6 times and nearly had a heart attack. In one case, I had to stop the trial and go, I got to find my pen.
Can I have a recess, Your Honor?
And this is the binder that I was, like, I was out shopping just before I got called to the bar, and there was this old luggage store on
Gold's.
Queen. Yes.
Gold's was the best.
So Gold's
had everything.
Had a section of binders, leather binders.
I remember that.
Like, look at the.
I know.
What do you call this? The
clippy things, the rings.
The rings, like solid. So this is from 1993. I've used this for every single trial.
When were you called to the bar?
1991.
Wow.
So I bought this just.
Me too.
No, sorry. I was called February. February 9th, 1993. But
we articled in 91.
I articled in 91.
And we got called in
Which
93.
is when I sort of got into like the pens and I saw some of the lawyers with binders, and John Rosen had one when I was with him. So I just before I got called to the bar in 93, I went looking, and Gold's had like nobody has like a great selection. So I was very proud of getting it, and I've used this consistently since 1993 in this, and it's like superstition.
Yes.
But like it's important. Although I was chastised once recently in a Superior Court trial by some judge who couldn't get the hyperlinks working on the case lines,
that one.
and was saying paper is dead, like it's old school, and I'm like in my head going, okay.
At my recent trial last week, I had to set a continuation date. You know how evil Outlook is looking for on the calendar? At one point, I just threw my threw my phone down.
It's not just that. It's like I don't know how many times like you cannot conduct and learn and do a cross-examination from your laptop. No. And it's funny how some people are out of touch. Like this judge was like, it was almost like ageism, although like, I don't think we were that far off in age. But anyways, I'm like, I had my binders laid out with all the disclosure and everything and this and that. And I just thought this was highly inappropriate. And I'm a fairly effective cross-examiner. And I think I'm known for that. But this is the way to do it.
Right.
And we don't allow our associates to do it any other way. But call it superstition or what, but we know how to marshal our case along. But these are important elements.
They are. No, with my setting the new date, I just tossed my phone. I said, I give up. You guys pick a new date. I can't even
That's why I have my day timer.
I'm going to resurrect mine. Evil.
Yeah, we have everything on the computer system, but as we can tell you, like...
Try accessing that on the fly.
And if you have a data corruption or a hack...
Right. Game over. Or
you know what can't be hacked? My f***ing leather day timer.
No,
that can't be hacked.
Now I know what we're getting you for Christmas.
What are you getting me?
A leather day timer.
No, I have the Filofax.
So some of these are selling for $800 and $1,000?
Especially the fountain pens.
Yeah, there's a ballpoint.
It'll get you a lot still.
Unbelievable.
It was.
You know, my other superstition we spoke about was...
What?
So in my early days, I had bought like a Rolex for like not a lot of money back then.
Yeah, back then.
And I always wore that watch for trials. And then when I could afford better, I sort of upgraded that one. But those are my superstitions.
Yeah, we all have them.
And did you bring a special watch for our show today?
I did bring a special watch.
This is kind of cool. This is what I love about our podcast and certain things. So we have so many loyal and really great viewers. And Doug from Saskatchewan, who's a great guy we communicate with over X, is a watch enthusiast, has a really interesting career, is really interested in our podcast, is an expert in the area he is, so he's in court cases. And so, Doug, if you're watching this episode, I'm talking about you.
It's dedicated to you, Doug.
Yeah, and we talk often about watches, and he just loves Rolex and stuff. But
this one,
we love watches, and like I love it so much that my hair's.
Is there a piece of hair?
I'm going bald. There's nothing I can do about it.
You have 2 pieces here.
Well, it's because it's the only 2 pieces back there. So this is watch parts.
Yeah, I know. I've seen those. They're very
So these
cool.
cufflinks are made by real watch parts.
Yeah. Very cool. I've seen those.
Anyways, the guy who made this, Dan Tenenbaum in Toronto, made a bunch. He's just so talented.
Oh wow!
I bought it years ago, but he was handmade. Just amazing.
You go first with your.
No,
watch.
mine's nothing. Go to that.
What do you mean yours is nothing?
That's a classic.
This is a rare 1960s.
People are so going to tune out of our podcast because of
but
this
at least
now.
we'll have fun.
We're having fun.
1960s Seiko certified chronometer. Explain what chronometer means.
Oh my God, that's a certified chronometer from them.
See how excited he's getting? Yeah. Tell us what that means.
Well, you have to satisfy certain test levels.
Swiss test levels. At a laboratory. To be certified as a chronometer. One day you and I will be certified.
I think I already have been.
Probably.
I mean, now you have cost certified, right? Right. So you have to reach certain levels with cost testing so that you're at a level of accuracy. I forgot what, I really don't know what it is because I'm not one of these watch podcasters, but it's like within 1 to 3 or 5 seconds.
Because that's important.
Right. And you got to withstand tests with magnetism and all sorts of other stuff. So that's like a major certification back there. And Seiko, the Grand Seikos are like great watches.
Yeah, I bought it. Poor guy going through a divorce, needed some cash.
That's great. Can you take that off for a second?
I will. It was a win-win. He could go fight his wife in court, and I took one of his watches.
Oh, that's really cool.
Yeah.
That's cool.
It's cool. I have quirky watches.
Yeah, you have some that I just don't want you to wear. I know.
But Mickey Mouse is not allowed in the office. But yeah. But I snuck it in for this episode.
That's really cool.
It is. And why is this episode important apart from being the 140th?
Well, because I'm bucking the trend and I'm wearing my Omega. I talked about...
Not just that. Marcy made cookies.
Oh, thanks, Mars.
Thank you,
I'm not having them. I'm on a diet. I'm trying not to sausage myself into my vests anymore.
Okay.
I love Omega.
Meanwhile.
I really do. And
Tell us a story, Uncle Joe.
Omega was also one of my first watches. I had a Seamaster like a billion years ago, and I always liked the Planet Ocean line. And, you know, I got a couple Planet Oceans.
Just a little bit.
No, it goes to my hips. I'm not doing it. And like this and the Submariner to me, like there's always the talk about what would be your one watch collection, which is sort of absurd, but that's
totally
a concept.
absurd. That's not a collection.
And I always thought the Submariner date would be perfect for a one watch collection because that's just iconic. It's quintessential, like a Rolex timeless piece. But I think, you know, for the Omega line, this has got to be, frankly, to me, the best product.
Show people.
In a long time. Well, it's here. We have a picture of it, but I love it. It's great. A little girthy, but you know, there's nothing wrong with a bit of girth. You're not girthy. You look like you're slimming down there and healthy.
Well, these cookies will help. Yeah.
And you're not on blood pressure medication, nor on cholesterol medication.
No.
You're like a vampire. Your blood's like a vampire.
I have perfect cholesterol.
All right, so let's talk about cholesterol and high blood pressure because
today was one of those days.
Today was one of those days, and we're gonna just update everybody because one of the cases we've spoken about a couple of times was a complainant who, oddly enough, had to be on 2 of our cases. She lied on the first case where it was a clear fabrication, and then sure enough, she shows up on a second case where Amy identified it's the same complainant, and this was the one where...
By the way, Amy loves when we do shout-outs about Amy.
Amy,
you're really good.
Our senior law clerk, she's great. She had videotaped the actual sex act, and she was orchestrating it and directing it, okay? And our client was extremely embarrassed and finally turned it over. Right. And it's been disclosed to the Crown. And our episode was about will she or will she not be charged, because it's clear from the video that she's not only consenting...
Hey, she's having a hell of a good time.
Yeah, but she's directing this, right?
Yeah.
Where she described to the police what was a sex assault.
Right.
What's the update?
But you forgot, yeah. I was
Well, tell us more.
You forgot the important part. So,
I thought that's pretty important. But
well, that part's important too. But came across a decent crown, which is nice. It happens.
There's a lot. There's a lot of good crowns.
You know,
I don't want to be one of those people who's
no.
We've had a lot of excellent crowns.
Oh yeah, and this was a former defense counsel, so she had become a crown, so she got it. I said, look, I'm going to give you this USB. Don't watch it with anyone else. Just watch it. Compare it to your disclosure, and you will see that at the precise time she claims she's being raped, she's directing an amateur porn.
Well, you also did a breakdown.
Yeah, yeah. And the Crown just said, are you kidding me? I said, I kid you not. So she called the Crown from London on the previous case, and she got a very clear picture of who the complainant is. She actually met with the complainant. I would have loved to have been a fly on the wall in that conversation.
Yeah.
And she's told us, yeah, I'm going to withdraw the charge. Maybe if you guys can just agree to a common law peace bond, just that he stay away from her. I said, no problem. He has no... And although I find it kind of
it's offensive.
It's offensive. It's like if you're going to withdraw, just do a straight withdrawal without conditions. But, you know, they got to cover their behinds. I get it.
Well, the other thing is that the client's got to get out of this.
Right.
Otherwise, that's the compromise in this.
It's a compromise.
And it sucks.
Crown's going to withdraw it, and likely nothing will happen to her. Now we start the rant part, everyone.
So here's the thing, and this is something that's a pet peeve for us. So
yes,
even though there's more than credible evidence that the complainant fabricated.
Yeah, this isn't a beyond a reasonable doubt where the judge has, you know...
The choice that our client had right now was sign a common law peace bond, no contact, charges withdrawn, there's no admission of civil or criminal liability, we can put on record there's no reasonable prospect of conviction, the complainant had actually videotaped the actual incident, right. and it's pretty clear she's consenting. So there's no negative to the client, but it's offensive that the client has to sign anything.
Right.
And two, it's frankly a very clear picture, as we have seen in multiple cases, that even though there is clear, cogent evidence that a complainant has fabricated an allegation, there will be no investigation, there will be no charges.
No, not that we know, but I couldn't imagine it'll happen. How often, have you ever had a complainant investigated?
No.
See, neither have I. Never.
But this was one of the most stark examples because we had real-time, real evidence.
Real evidence. Like, this isn't iffy. You know, many of our cases, you know, the judge will say, well, I believe him, I believe her, so I have to acquit. That doesn't...
No, but even in cases where we have the judge saying that I believe that the accused is factually innocent.
Right, right.
No, factually innocent.
Oh, factually innocent, okay.
And in cases where I've had where it's very obvious, even if he or she doesn't say factually innocent, meaning the judge,
right.
There's evidence that's been clear about fabrication. Clear.
Right.
There's no investigation that ensues.
Right.
And so leaving aside where the judge is saying,
right.
you know, I can't find beyond a reasonable doubt, I believe him, I believe her, all that type of bullshit.
Typical, but you're talking about...
But in cases where there's close to factual innocence or factual innocence, they still do not get investigated and charged.
No.
We've talked about reported cases where there have been a few. But this is one of these... I'm sorry that we harp on this, but this is one of those examples where it's videotaped.
There's been two...
It's real evidence. We know from way back in the Bernardo case, when you have a videotape of the actual alleged crime or incident. It's real evidence. This is real evidence of the actual incident. So they have real evidence of the complainant lying about what she said was a sex assault. You know, no investigation.
And early on, the Crown, you know, well, you know, it's not like a live stream. These are video clips. Maybe something happened in between. I said, oh no. Look at that smile on her face. It doesn't look like anything happened in between. It's like the metadata, right? We looked at the metadata.
Yeah, you had the metadata.
Yeah, the times, the Airbnb, everything was GPS. There was no doubt where they were, when they were there, and
there's no issue about editing at all.
No, God, no.
So it's properly authenticated, timing, all that's accurate. Even though there may be clips, it's a pretty coherent picture of what happened.
Right. Throughout the evening, not just, okay, later in the evening or early in the evening. It's...
Wow. So concerning is what could happen next with this complainant. You know, who could she go on and victimize next?
Right. Anyone else who she feels has pissed her off and broken up with her.
And they're still protected by publication bans, or their name.
Yes.
Obviously, we have to be careful not to publicize that or do anything that would identify the person. But this person can go on with impunity to act the way they act.
Yeah. Strike 3. Next boyfriend who doesn't make her happy. Or makes her happy, but she's still...
Terrible.
Yeah, bunny boiler material. Do you think people in the audience know that phrase?
I think most would, but you can explain it comes from that movie with Glenn Close. So
Yes. What's the title?
Fatal Attraction.
Oh, good.
Wouldn't let him go, so boiled the bunny in the pot.
His bunny, pet bunny.
Yeah.
Yeah.
I don't want to diminish the impact of this. It's like, you know, these cliche terms or whatever. This is like a serious, this is like real evidence where you can be fairly satisfied beyond a reasonable doubt that the complainant has lied.
Right.
And it's put somebody's life in turmoil. And we just have this institutional and societal lack of desire to hold accountable those people who lie.
Right. And it's so rare. Remember we found that Hamilton case.
Yeah.
Similar though, right? There was real-time evidence. She spoofed his phone. Like, it was provable.
The police did a wonderful investigation in that case.
Yes, they did. And it was complex. This would be very easy for them to investigate. So
yeah, and that was a scary case because the complainant had actually cloned his phone.
yeah, spoofed his phone number.
Yeah.
And pretended to be texting messages to her from him. That was scary.
It is scary, especially when you consider now the level of technology and the ability to hack into people's social media, to hack into their phones, to hack into their email and create false emails.
You're being spoofed, and we're all being spoofed recently.
Yeah.
I got an email from Joe this morning. Are you free this morning? I'm like, oh, I'm not free.
Not me.
And then I always look at the actual email and then reveal. And I said, you're not Joe. But if you don't have that level of sophistication to like look at the address.
No, but so the level of, you know, technology, the ability to access, because we're such a computer age now.
Oh God.
And then with the rise of AI, like this shit's going to get even worse.
Oh, it's going to get worse. They can make a replacement of you online.
And unless they have, you know, robust laws now about when you find fake and false information and fake allegations, you take action on it, there will be no disincentive for people to do this type of thing.
Oh, no. And we're going to be in a gap. The law is always behind, right? Although in the States...
It's well behind here in Canada.
In the States, they're catching up to all this AI stuff and, you know, making fake... You know, Donald's been accused of making fake... I don't know who Musk has done it. There's been a fake Musk talking. It's not that hard anymore.
No, it's not.
The laws... It's catching up in the States, but here we are, like, nowhere close.
All right, let's move on to another case study because that's just depressing me.
It is.
I mean, it's a good result for the client, but it's very...
a lot of emotional, financial struggles to get to this point.
And then he's got to clear the notation on the computer system.
Well, yeah, that's next. So he's going to have to invest in the fingerprint photograph destruction. And
no, but the police service may say, well, we have a policy not to expunge, in which case that'll have to be appealed and challenged.
Right. But the worst problem is if it's a 12-month peace bond, he has to wait till its expiry. So it's another year of he's crossing the border at the U.S. They're hardcore there. They're badasses.
Oh, if anybody has an outstanding charge of sexual assault or a series of domestic, do not travel to the U.S.
No, don't. You won't.
At least don't fly because they will bar you entry now. They don't notice when something is outstanding or withdrawn at the moment. No, they don't
care. It's like they see sex assault. Sorry.
Yeah, we've had that happen a few times. We have to be very careful.
Well, remember, did we discuss the new trend on the last episode? The passport seizures?
No, we were going to do that on another one.
Okay, yeah, we're going to
talk about it for a moment.
Yeah, we can talk about it briefly.
It's listed, certain listed offenses, but
we're going to have an immigration specialist in an upcoming episode to talk about this. But many of my clients, I don't know if yours yet. I've had this happen. Oh, have you? Like I've had a number of clients recently saying, "WTF? I just got this letter from Immigration Canada or whoever, whatever government. They're taking my passport away. I haven't even been found guilty.
Yeah, so they get notification that they have their passport is either being canceled or they have to forfeited, and they're charged with offenses, most of which involve offenses like luring or sexual interference, human trafficking. But it happens with a client who's charged with sex assault, but also sexual interference. So it's somebody under the age, which is a listed offense. So their passport's forfeited, even though they're a Canadian citizen.
Or held, they call it.
Right, but they're a Canadian citizen.
Right, Canadian citizen.
So, and there's no restriction, let's say, on their release order for travel.
Right, that's what.
But you can't have a passport. So in that case, then they are left to being prisoners within Canada.
That's terrifying.
It is terrifying because as heinous as certain offenses may be, if you're born in Canada and you have a passport as a citizen, that being taken away from you is a very draconian step.
I'd argue it's a charter violation, mobility rights.
Well,
potentially.
We'll have to get there.
Yeah, we'll get there, yeah.
But it's quite frightening, and we're going to have an immigration expert on to talk about it. I see it when it's in relation to other issues like terrorism, and if you came into Canada, obtained citizenship under fraud, or engaged in terrorist acts or other offenses similar to that, you are using your Canadian citizenship to further certain criminal acts. But when you're charged with sexual interference, and it just happens to be because the complainant's 17 as opposed to 18 or 19.
And your trial's months away.
Or a year away.
Or a year away. Well, and the clients are asking me, what's the basis for this? And all we've been able to kind of scratch our heads and cobble together is the police may be tipping off, right? Because how else, right?
Yeah.
That they're potential flight risks, so take their passports.
Well, I think they send I think in certain cases they send a notification to the Canadian agency, and then it happens.
Right, and no one knows why.
And if anybody's charged with, human trafficking, for example, and this can be labor trafficking as well, just to pause for a moment. So we're not talking about necessarily human trafficking of young persons for sexual issues, so which is, of course, a very heinous and serious offense. But also labor trafficking, which is now under the same provisions for human trafficking. So this is about labor migrants who come into Canada and they're, let's say, allegedly controlled by a person who's hired them and has their passport in their control and not paying them sufficiently. They can be charged under these provisions. And notification goes out. Their bank accounts are closed. They can't have a mortgage. Their life is really so disrupted that they become almost homeless. Right. And so that happens. Like there are things to consider here that may be beyond the pale when there's the presumption of innocence still in place.
Exactly.
Well, we're going to tackle that in another episode, but there's a lot of things that are out there beyond simply just the charge itself now.
Right, people don't know.
That is happening to people, which is really bad. And this is actually a good segue to a case we spoke about sexual exploitation, where the client has now been acquitted.
Yeah.
And we've talked about this in a few episodes, but this may deserve, this episode and maybe possibly another one, because of the intricacy of the analysis and just how easy this person was before the court in circumstances where we all thought this was like a no-brainer. The case should have been withdrawn or never even got to the charge. Yeah. So why don't you set it up again, because people may not remember this.
Right. So this was a great case because I think everyone in the firm worked on this. It was a true team effort, which resulted in this acquittal. So we had a trial on this. The client was charged with 2 counts, 1 count of sexual assault and 1 count of sexual exploitation. And this arose in the context of a relationship. He was roughly 35 at the time, and the woman, I guess young girl, she was 16 years old at the time, and she was working in the sex trade and living in a youth shelter. And it was in the context of this relationship where They used drugs together.
They were
and,
both, unfortunately, addicts.
Yeah, they were both addicts, and you know, the claim by the Crown was that he was, you know, giving her drugs to induce her to have sex with him. He really two issues that the judge identified as, you know, the Crown having to prove in this case. Firstly, with respect to the offense of sexual assault, the framework, I guess, of the Crown's charge was that the client was in a position of power in relation to the complainant. He abused that power, and as a result, her consent was vitiated. What's a simple word for vitiate?
Null and void.
Made invalid.
Doesn't exist, invalid.
Yeah. And with respect to the offense of sexual exploitation, the Crown was alleging that he was in an exploitative, God, that's hard to say, exploitative relationship with the complainant, meaning that he somehow took advantage of his position with her and that there was a power imbalance. So that's kind of the framework of what the Crown was alleging against him. But like as Joe said, they were both street addicts. She was living in a youth shelter. He was living at home with his parents. No real source of income. So
no, quite down and out at that time.
Yeah, totally down and out.
Even though he was, in these facts, we're not going to talk about exactly his education because, again, we don't want to identify anybody.
No, we can't, yeah.
But was an educated individual but had not succeeded. As a result of that failure, had fallen into depression.
Deep depression.
And drug use to deal with his depression and to deal with his sense of failure. And again, at the crux of this was what the Crown was alleging, which is appropriate under the code, was that there was this power imbalance between the accused and the complainant, which he abused to induce her to consent to a sexual relationship.
Right.
And it is, what is that power imbalance? What is the facts that create that power imbalance that's relevant? And then what's the intent on that?
Right.
And this is really serious because
it is.
You can expand this principle
to a lot of
scenarios, and we see this playing out in many charges now where you see people who are, you know, successful business individuals or celebrities or whatever, and that power imbalance is being used to vitiate consent.
Right.
And we've spoken about this a number of times, that people who are in these positions as a celebrity, a sports person, or a successful business individual are quite vulnerable to these allegations, even though they may not have intended or even used that power imbalance in any way, shape, or form.
And the criminal code, which allows for an inference of sexual exploitation, there's basically four factors. Slow.
Yeah.
The age of the young person, the age difference between the young person and the other person, the evolution of their relationship, and the degree of control or influence by the person over the young person. So when you hear those criteria, you initially think of situations like, okay, teacher, student, hockey coach.
We think
player.
of the traditional.
The traditional, you know, but this case was far from traditional in terms of those criteria.
So again, we're dealing with people in this instance that are under 18, but again, we're talking 16, 17, and yes, there's an age gap, but one can appreciate that somebody who's not 35, it can be somebody in their 20s as well. So you're not having such a significant age gap. The factors that are involved can be quite amorphous and highly vulnerable to manipulation.
Of course.
Talk a little bit more about what was the, you know, sort of the key legal issues that had to be like drummed out in this case.
Well, we had to establish that this power imbalance did not exist, that he wasn't exploiting her, and to the contrary, I relied on most of his cross-examination he drafted. It was quite good.
It was very good.
It was very okay. You know, she agreed in her statement that at some points of the relationship, many points of the relationship, she was actually using him to get drugs and manipulating him to get drugs. So that was a really important point that came out in terms of, you know, kind of identifying, well, was this a power imbalance or not? Like, and you know, the evidence that came from her was, you know, especially after the cross-examination, she had her own source of income, more so than him. She was, you know, getting government assistance. She had a shelter. I believe she got some assistance from her family. And she had established drug dealer relationships. So this wasn't someone who, and of course she was in the sex trade for a portion of her relationship prior to meeting him. So it was clear that this was not a, you know, unsophisticated, vulnerable complainant. This was a street smart 16-year-old, basically 16, 17-year-old at the time. So she knew what she was doing. She agreed she took advantage of him. She manipulated him. She would often, they would go, you know, source drug dealers, ones that she knew that he didn't even know. So she was quite sophisticated that way.
So let's sort of drill this down. So what was important was, in the cross-examination, it was important to establish that there was not a relationship of dependency between the complainant and the accused, and that regardless of her situation, it became clear that the complainant was, although youthful, was smart, independent, articulate, mature, streetwise, and had resources and skills, maladaptive as they were, to handle her circumstances. And so even though many of these things that she exhibited, which are not necessarily a healthy thing, supported the fact that she was independent, self-determining, resourceful, and not at the dependency and mercy of our client.
No, far from it, in fact.
And this is an important consideration.
It is.
Because when you look at the relationship between the two, and you look at the legal test, this type of evidence was not supportive that the accused had manipulated or controlled the complainant.
Far from it.
And that she was not as vulnerable or manipulated by the accused as she had alleged. These were important factors, and you do not sometimes have as much information as we had that we could draw on for cross-examination to concretely establish these facts. And that's really important, like super important.
It is, because he testified that he didn't have any power over her. Far from it. She would often ghost him on their text messages. He was the one, I'd argue, or I think I may have argued, was in a worse off situation than her. He was an addict. He was depressed. He was unemployed, broke, in debt, no source of income, no career, no car, and lived with his parents. Like, if that's not...
So his position, and this is something we need to be careful about, because in this case, it was clear that that this alleged power imbalance was more in show than reality because of his own personal circumstances. But what's important here is you can still have an innocent person who doesn't have those circumstances, that may be successful in life. That doesn't mean that they're going to manipulate or create that type of power imbalance. And we have to be careful that just because somebody may be successful in their life, whatever it is, doesn't mean that they're going to be guilty of exploitive conduct.
Right. And precisely in this case, like, it was clear by the time we were done our chief that we established, okay, this guy, he's probably in a worse off situation than her. She had a regular source of income. She had a support network. She did drugs. And I guess one of the most important things as well in this case was he wasn't interested in sex in the beginning.
No.
They were drug buddies. They were drug buddies. And, she experienced a bit of trauma at one point, and, he was very comforting to her, and, one thing led to another
they had
over time.
A relationship of codependence,
right,
where they spoke about their issues and they shared in each other, and it did not start out to be anything that was sexualized.
No, far from it.
Okay, so let's bring this back to the legal test for a moment. So this is a good factual basis. So let's look at one factor.
Okay.
One factor is the age of the young person.
Right.
So we know that the complainant in this case was 16 or 17 years of age, and that the accused was older.
No debate.
Okay, so we're talking about 18, 19 years older.
Right.
But because the complainant in evidence was established to have been somebody who was, at least in some ways, mature, independent, strong-willed, and self-determining, that age discrepancy was not significant.
No, and this is what the judge said as a general. The judge said, there was a large age difference between the defendant and the complainant. As you said, 18 to 19 years. A large difference between an accused and a complainant on its own does not necessarily mean that a relationship between them is exploitative of the younger person.
So that's important.
That's important, right? You know, the greater the age, she also says, however, the greater the age difference, the more the complainant may be vulnerable to apparent exploitation by the defendant. But in this case, you know, that wasn't the case. She found, you know, that they were almost, as I said, she tried to manipulate him. She was very strong-willed and very mature for her age. So
as a principle, let's just be clear, so people who are interested in this, a large age difference between an accused and a complainant on its own does not necessarily mean that a relationship is exploitive.
Right.
And that's Regina versus Martin, 2011, ONCJ 401.
Right.
Okay? But as you noted, the greater the difference in age, the more the complainant may be vulnerable to apparent exploitation by the accused. And they're referring to the Anderson case.
Right.
So these are factors to keep in mind if you're defending this type of case or if you're stuck in a case like this.
Right. So the judge said, you know, the evidence could support a conclusion that the relationship was exploitative. However, she said the complainant also testified that she liked talking with him because he was mature, that they had great conversations. I think, you know, she invited him over to her parents' house to look at some art. They would go to parks. They would celebrate events together. So it definitely wasn't black and white.
No, and so what was borne out through the evidence was to establish that their relationship was not based upon an exploitive relationship. It was based on a commonality of interest, sharing of information, personal experience, talking about their lives and other interests.
Yeah, well, like the judge says, the age difference between the complainant and the defendant may have grounded a good and mutual friendship or even a romantic and sexual relationship that was not exploitative.
Okay, so let's look at the second factor here, the evolution of a relationship and what that means.
Right.
Okay, so that's important as well as a factor. So in this case, it's pretty clear what the evolution of the relationship is. Now, so you can imagine how the evolution of a relationship can impact on the analysis. So if somebody comes in contact with a complainant who is very vulnerable, and then through that creates a relationship of dependency and preys upon the vulnerability, and then almost grooms them, that evolution of a relationship can be quite indicative of what is the offense.
So let's reset the facts, for example. If she had not been involved in drugs at all, he introduces her to drugs, he gets her hooked on drugs, then yeah, we're headed in a negative direction in terms of the definition.
And in this case, what was interesting was the judge noticed that there could be competing interpretations of how the relationship evolved. Leaving that aside in this case, frankly, I think there was only one interpretation, which was frankly that it was just organic, unhealthy relationship where they found kinship in each other and enjoyment. But that's an excellent point that, again, you can imagine a fact scenario where somebody introduces somebody to drugs or alcohol and then grooms them almost in a way where they become more and more vulnerable and dependent. That is an exploitive relationship. So that history and that evolution of the relationship is an extremely important factor, but it's so broad it's defined by the facts.
Well, as the judge said, either
Let's
one.
just 1 second.
Yeah, yeah.
Forget about the judge in this case.
Okay.
Let's talk about other things.
Yeah, but she was a nice judge.
No, she's an excellent judge.
She's an excellent
But leaving
judge.
that aside, you
Right.
can imagine other cases where, and we're seeing it in the media. So somebody can say, okay, I'm the CEO of a company.
Right.
And we sell clothing. And so do you want to be a model? You know, some young person, come on in, come audition for modeling, and then you bring them into the company at some bullshit level, and you start to groom them and take advantage of them because they think they're going to be a model or they think they're going to be doing something in the company, and you start to move them along that way. That's an exploitive relationship. Yeah. The evolution comes from one of dependence, where you're coming in as some pseudo-employee with the promise of some hope of doing something in a career. That's another example. And we see this playing out right now, real time, both in the United States and Canada.
Right.
So, you know, that's extremely important. You can see how these relationships can be based in something which is quite exploitive.
Right.
Not in this case, though.
No, God, no.
And that's why you have to be very careful about what the facts are.
Of course.
Let's talk about the third
next
one.
principle, yeah.
The degree of control or influence
Yeah.
by the person, the accused, over the young person.
Right. So as the judge said, one possible interpretation here was that the accused had control and influence over her because he was older. He had access to money, not really in this case, and was able to provide or withhold drugs and transportation to the complainant. And that he used these to control and influence her to get her to apparently consent to sex. But as the judge said, but for reasons I've already explained, I'm not convinced that the defendant had such control or influence over the complainant. I love how she describes the complainant. She was mature, smart, independent, and she may well have had some power and control over the defendant in the relationship. I accept that the defendant loved her, she knew it, and perhaps this was a relationship of power imbalance with her holding all the power.
Pause. So this is important. So this is, again, where the cross-examination was important to establish that although the complainant was much younger, 19 years younger, she not only was mature, capable, street smart, and had independence, was able to manipulate her own position and his feelings towards her to her advantage.
Right.
And this cannot be discounted because one might assume that just because an accused is older, that they know better and are not vulnerable to a younger person. And that's bullshit.
Watch Lolita.
You can see how it is a two-way street.
Right.
And you have to be very careful in these cases where they allege exploitation to really lay out the foundation of the evidence to show that, in fact, we say defendant accused. The person who's accused of the offense was vulnerable and was manipulated.
Right. Like the judge said.
And their feelings were exploited.
Right. Well, and that's what she said. The judge says the complainant had the ability to give or withhold her time, attention, and willingness to, hook up with the accused in this case.
So kudos to the judge who noted the factors with respect to the degree of control and influence and said that the evidence allows for a conclusion that that the power imbalance could have gone both ways. You know, although the defendant had age, education, contact with his family, access to funds, etc., the complainant had the ability to give or withhold her time, attention, and willingness to engage with the defendant. This is really important.
Huge.
Okay? It cannot be discounted that that is power.
Yeah.
Especially if the male party, in this case it was a male party, because it could be same sex, it could be versus, was vulnerable because of his emotions towards her, his love of her.
Right.
So this is really important. The complainant had the ability to give or withhold her time. That's a part of her own independence.
Right.
Attention, part of her own independence.
That's right.
And the willingness to engage with the defendant. Her own willingness to do these things. Her own control and her own manipulation. It cannot be f***ing presumed that these things are always in the control and power of the older, successful person.
Right. Especially on these set of facts, right? She said, there was certainly evidence from which I could conclude there was transactionality on both sides, but there was also mutuality.
He testified very clearly that she was beautiful, smart, and funny, and he wanted to be with her. So it was clear in this case that it was possible that this gave her personal power within that relationship.
And it did. You know, he testified how she would ghost him, not be responsive at times. He'd have to chase her to get her to respond to him. Yeah, no, it was definitely not a case of him taking advantage solely of her.
And one of the interesting issues here was the mental intent of an accused to act upon what could be considered to be a position of power. So let's remove this from this case for a moment and just think about this a little bit more academically. Again, a person can be in a position different than this case. A person can be older, having a successful career, having access to funds and other resources, family connections, and dealing with somebody who is more vulnerable just by their own personal circumstances. But again, there has to be an element that the person who is accused of the offense actually intended to act upon those factors.
Act upon
and
them,
use them. And that's all borne out by the facts.
Yeah.
So that's important to consider as well. It's not just an objective analysis.
No.
It has to be subjective as well.
Yeah, especially on this set of
I mean,
facts.
this may seem to many to be like f***ing duh, Neuberger.
Yeah,
of course, we
of
understand that. But you can easily fall prey to seeing sets of facts. You know, successful individual, older guy, older woman.
Older woman.
Please, let's be
it's
fair.
Possible, yeah.
Or same sex, whatever.
Whatever.
You know, older person, access to funds, great career, you know, has a home, car, all sorts of stuff. Younger person who doesn't have this stuff, ergo, must be exploited.
Must be,
yeah, no. That's just on its face. You got to dig down and really see. Yeah. And then there's got to be evidence that this person really wanted to act on that basis.
Well, I was going to say, they have to act on that, on all the stuff they control.
It's not just simply by the objective view of it.
It's not one-dimensional by any stretch.
But it's that objective analysis that bothers me, because there can be, you know, you can get into the debate and say, well, I mean, look at this. Of course these factors show that it's exploitive.
Right.
No.
No.
It's not that simple.
No.
But, you know, in a case like this, the access and ability to cross-examine the complainant was luckily borne out in a number of messages that were exchanged between them that was available as evidence.
That's right.
And there was also the benefit in this case that the complainant had in fact seen, we talked about this before, a therapist.
Right.
Where the therapist had been saying to the complainant, you were exploited, do you not get it?
Do you not get it?
And the complainant was going, huh?
Yeah, was it?
I didn't think about it at the time. I thought, you know, I was exploiting him.
Right.
I was exploited? Oh, okay. So we had the benefit of like a really robust foundation of evidence to mount a strong defense for the client. That may not be available in so many cases. And so there is a real risk. And that's why we have to be very careful with cases that are built on this power imbalance. And I think it's something that there's no doubt that there are allegations and historical allegations where people have used their position of power to abuse other individuals. No doubt.
Of course.
But we got to be very careful about what's real in these cases and what's not.
Yeah, what's behind everything. That's so critical.
I'd like to come back to this.
Okay.
I think it's worth... Max, where are we on this? Are we running along? Because we start off with all this other shit. Okay, sorry about that. Yeah, it was fun. Yeah. And you still got the watch here.
Yeah.
This is really cool. It's really cool.
I know. Maybe,
but I think it's worth taking another deeper look into this because we, you know, there's other cases that we have that are dealing with exploitive relationships, and it seems to be a timely issue now in the media with other charges out there. I mean, there's just an arrest now in the United States with a CEO of Abercrombie and Fitch.
Oh yeah, I saw that.
You know, that we're looking at, and frankly, that may lead to a conviction, and the complainants may be totally telling the truth. But again, on its face, you've got to be very careful about this and not jump to conclusions.
No,
so I think I'd like to come back to this in another episode and do a little bit more of a deep dive.
Deep dive, and maybe find some other cases that are similar.
Yeah, so Pillow Talk.
Pillow Talk. Whose pillow is closer? I think yours is closer.
Jesus.
I know, I'm just being lazy.
All right, let's see.
What is B? No, BJ's got a certain order.
BJ's not here, so we can do what we want.
Really?
Yes.
Okay, so don't what help.
He is
here,
not
Mike.
exerting power on me.
He's not
That's
exploiting
what I want
me.
to say.
Right. Don't forget to like, comment, I think share, subscribe. Doesn't matter.
And the comments are great because we
They
get
are.
such great questions and comments that lead us into other areas.
Yeah, and send us questions, please. What's your favorite watch?
Or ask us to clarify something in a case. So
Okay.
this is great. Thank you very much. Again, this was a case that I think we visited it 2 or 3 times in podcasts.
Yeah.
But it was one that really grabbed our attention because it was so interesting.
Well, it was a
and unique.
perfect example.
Yeah, it's like a real law school type of case.
Yeah, totally.
So thank you for watching. Thank you for all your comments. Again, thanks for all your support and have a good night.
See you soon. Thank you.
Did you have another cookie?
No, I didn't.
Okay,
I'm
I'm not.
watching my girth.
Good night, guys.